Well, I just want to welcome you to this event. My name is Andrew Cohen. I am a media fellow at the Brennan Center. I write for The Atlantic, and I work for 60 Minutes and CBS News Radio. All of those organizations are very interested in the U.S. Supreme Court. All of them are going to be covering in various forums the coming term. And so what we wanted to try to do for you this afternoon briefly, and in a way that's maybe a little bit different from what you're used to in the Supreme Court previews, is to give you a sense, to scratch the surface, if you will, of what we're going to expect from the court this term. So the Brennan Center for Justice, both the Washington chapter and the New York chapter welcome you. The NYU is where we're sitting in these nice new facilities, so we're grateful to them as well. Before I introduce our wonderful panel, I just want to tell you that when we initially thought of this, we of course contacted Lyle Denniston, who's the acclaimed dean of Supreme Court reporters. He agreed to do it, but on the condition that he be allowed to parachute in to an open-air event, holding in his teeth the rifle that Justice Elena Kagan uses when she shoots with Justice Scalia. And so, we tried to make it work for Lyle, but the insurance was prohibitive, and so we decided on an indoor event without Lyle and with our fine panelists, which is a good segue of starting with Amy Howe. Amy is obviously one of the founders of SCOTUS blog, which is the preeminent website that covers the U.S. Supreme Court, along with her husband, Tom Goldstein. Amy is a wonderful lawyer, a Washington institution, a graduate of Georgetown University's Law Center. She has taught at Stanford. She has connections to Harvard. She has connections to American University. And she's as much on the pulse of what's going on at the court as anyone outside of the court. So we're delighted to have her here. And of course, all of our panelists will be willing to answer questions later when they're finished talking. Next up on the hit parade is Garrett Epps, my respected colleague at The Atlantic. He covers the Supreme Court for us there. He is a former reporter for the Washington Post. He teaches law at the University of Baltimore, and he is the author of this fine book, which I will now promote, just out in August. It's titled The American Epic, Reading the U.S. Constitution by Garrett Epps. And it is a wonderful read for anyone who cares about the Constitution, which probably includes you guys since you are here. So we are delighted to have Garrett. He is a wonderful writer and is someone I never fail to read when I want to try to learn about what's happening at the U.S. Supreme Court. And last but not least, a Brennan Center person, Nicole Austin-Hillery. She is the director, first director and counsel of our Washington office. She is the chief liaison to Congress and to the executive branch. She focuses on criminal justice and voting rights and felon enfranchisement. She is someone who views the U.S. Supreme Court through the guise of her various topics and is a wonderful speaker and a great addition to our panel. So the idea is that between the three of them, and perhaps me from time to time, we'll be able to give you a flavor of what's going to happen. Now, the caveat, the condition is that we are sitting here on the last week of September, and barely half of the court's docket is full. I think it's 43 or 44 cases have been accepted. Dozens and dozens more will be accepted. Many more will be accepted following the conference that takes place at the U.S. Supreme Court next Monday. So we're trying to preview this term is difficult. It's sort of like trying to preview a baseball game when it's halfway done. The court is going to accept for review many more cases than it already has. Some of those cases that it's going to accept are going to be very prominent cases, and we'll try to touch on a couple of those as we move forward. And what we try to do here is to make this a little bit different from all the previews that you've seen or that you watch on C-SPAN by breaking it up into different categories. So the power of three, that's our theme after we failed to get Lyle. The three biggest cases, the three most underreported or undervalued cases, the three most likely dissents. These are categories that are basically designed to give our panelists an opportunity to identify cases that go beyond the cases that you've already heard about, perhaps go beyond the campaign finance case, the abortion case, the affirmative action case, the recess appointment cases. You've all heard a lot about those, and you'll hear about them a little bit more as we go forward, but we're trying to give you a little flavor for some of the cases that may not make it onto the hit parade. So what I'm going to do now is I'm going to sit down and shut up, and I'm going to hand it over to Amy. She's going to, and then we're going to go down the list. And the first question, the first topic is 3 biggest cases of the term.
All right. I am going to start actually with my favorite case of the term, and I think it's one of the biggest ones, which is the NLRB versus Noel Canning, the recess appointments. And this is the challenge to President Obama's appointments to the National Labor Relations Board. It started out as a dispute about 40 cents an hour and wound up in the Supreme Court. And it's fascinating to me for a couple of reasons. The first is that it is not necessarily something that breaks down on ideological lines. And I know this because in my past life as a lawyer, I spent many, many hours challenging the recess appointment of Judge William Pryor to the U.S. Court of Appeals for the 11th Circuit, which was a little bit awkward one year when his niece was in my class. So we brought several cases up to the Supreme Court. Some cases we did amicus briefs, some cases we helped with the cert petition, and it was like trying to get Goldilocks's chair, like trying to get the case that was just right. The court held on to all of them for a long time, and then finally issued a denial. And Justice Stevens wrote, not a dissent from the denial, but an opinion respecting the denial that said essentially, well, we trust that this isn't going to happen very often. And the Bush administration did not go to the recess appointment tool very often after that, and the issue went away. And I kind of stopped paying attention to it, moved on to full-time blogging, and then last January I got an email from one of the lawyers that we'd worked with on the various challenges during the Bush administration. He said, hey, we won in the D.C. Circuit. They'd ruled that the president's recess appointments were unconstitutional. So, this is challenging President Obama's recess appointments, but it doesn't necessarily break down on ideological lines. Justice Ginsburg addressed the recess appointments case very recently in her speech up at the National Constitution Center, which is available online, and is really a terrific hour and a half listening to Justice Ginsburg. And she tipped her hand a little bit. She said something along the lines of, those recess appointments date back to George Washington. And in fact, the second Chief Justice was a recess appointment. So there's the constitutional analysis part of it, like trying to figure out what this clause in the Constitution means. What is a recess, and when does a vacancy have to happen? Does it have to happen during the recess? And this goes way beyond the NLRB, particularly given the gridlock in Congress right now. If the court rules that recess appointments are unconstitutional, it really gives the Senate tremendous power over the confirmation process going forward. All right, so do you want me to do my other 2 cases?
Yeah, if you want to jump briefly and then we'll move on.
All right. The other 2 cases are sort of, I think they're both incredibly important in and of themselves, but really provide a 1-2 punch. And this is Klein versus Oklahoma Coalition for Reproductive Justice, and then McCullen versus Coakley. Klein is a challenge to an Oklahoma law that restricts medical abortions that can be done taking a pill, to the label that has been approved by the FDA. So this prohibits off-label use of these drugs. The problem, according to the challengers, is that all of the doctors use the off-label prescription to administer these drugs, because they believe that it's safer and it allows them to prescribe the pills further on into a woman's pregnancy. So the Oklahoma Supreme Court struck it down. The Supreme Court granted review at the end of the term and immediately asked the Oklahoma Supreme Court to clarify some questions about the scope of the law. But this could be a case in which the Supreme Court restricts the availability of medical abortions, which is important in and of itself, but also important given the second case, McCullen versus Coakley, which is a challenge to laws that restrict abortion protesters around healthcare clinics. There's a Massachusetts law that prohibits abortion protesters from going within 35 feet of the driveway, the entrance to an abortion clinic, allows clinic employees to go in that buffer zone as long as they're acting within the scope of their employment. And so, if the court were to rule for Oklahoma and against and for the protesters in both cases, it could both simultaneously make it more difficult to get a medical abortion and more difficult to go to a clinic to get one.
Garrett, you're up. Thank you, Amy.
Thanks, Andrew. I will admit that when I got the format for this panel, I was a little stumped by the threes. I sat down to write my notes. The first thing that came to me were three kings of Orient you can no longer sue under the Alien Tort Statute. Three stooges who can arrest you and submit you to a DNA test, even for a minor offense, and then three witches who will probably not be invited to give the opening prayers in the town of Greece. I don't know how helpful they are, but when I looked at what are the biggest cases, there's some very big cases in all kinds of areas. But I, being someone who covers the court from the standpoint of what are they doing to the Constitution, just want to point at the three that I think are biggest in terms of being pure constitutional cases, giving the court a chance to write something not about the case law, but about what the Constitution itself means. And obviously, the first one is Noel Canning, because this issue has virtually never arisen. And it also gives us a glimpse at how this court is going to proceed when it's confronted with allegedly originalist decisions from below, because the opinion, and it was an extraordinary opinion in the D.C. Circuit, the panel says the Constitution says that the president can make appointments in the recess of the Senate. So we'll find out the original understanding of this by looking up the word "the," which is the kind of Bill Clinton approach to understanding legal things. But we have to find out what it meant, what the word "the" meant in 1787. And they said, luckily, there's only one book we have to look at, and that's Samuel Johnson's Dictionary of the English Language, which of course had been published in London in 1755 by someone who had no sympathy for American independence. But they looked it up and they found 6 words that said of or denoting a particular thing. And they said, therefore, there's only one recess of the Senate and the president loses. And my guess is that the court will do a slightly better job of analyzing this, but they're going to be faced with an issue, whether they look at, somehow really try to go back and look at the original understanding of this clause, or whether they try to deal with the practicalities. And as Amy says, it doesn't break down on ideological lines. A significant number of these conservative justices started life as executive branch lawyers, so it'll be interesting to see what they do with that. The second one is United States versus Bond. This is the case which I call microbiologists behaving badly, in which one woman, they worked together at a chemical facility. One woman began smearing the house and car of her romantic rival with various caustic chemicals, and the rival called the state police, who came and investigated her. They said, if there are caustic chemicals here, you must be a cocaine dealer. When they concluded she wasn't, then they said, well, there's nothing we can do. But the romantic rival then smeared the chemicals on the mailbox, which is federal property, and she was arrested by the Postal Service and prosecuted, of all things, under the Chemical Weapons Treaty, which is suddenly very relevant and everybody knows about all of a sudden, as a chemical weapons violator, because the treaty requires the United States to outlaw domestic use of chemical weapons. And this case involves her saying that the United States cannot make a treaty that intrudes this much on local concerns. And this has not come up since Missouri versus Holland at the beginning of the 20th century. It presents the opportunity for a real change in the federal-state balance. And one thing to note is that one of the big reasons why the Constitution was framed and ratified was that states would not observe treaties to which the United States was bound, and this was causing all kinds of problems with our foreign relations. So it will be interesting to see, this is the court that last term said, yeah, well, we had some problems with voting a while back, but it's not a problem anymore, so we're going to get rid of the Voting Rights Act. They may say, well, it's not a problem anymore, we'll get rid of the treaty power as well. And then finally, the third case, which is not attracting a lot of attention right now, and may hopefully never will, is called Madigan versus Levine, and it has to do with whether the discrimination by age by itself gives rise to a direct constitutional cause of action under the Equal Protection Clause. And some of it is statutory. Well, you know, I'm a con law guy, statutory stuff boring, but it is entirely possible that the court will get to this issue of how are we going to look at age discrimination as it relates to the Equal Protection Clause, because it is not protected the way, you know, race or national origin or sex. Nonetheless, you're not supposed to irrationally discriminate against people on the basis of age. And the question will be whether the court wants to give people access or restrict them to the proceedings in the Age Discrimination and Employment Act. So those are the three ones that are obsessing me in my little nerdy corner, and I hope people will enjoy them.
Great, thank you. You know, one of the things that I said to Andrew when they first asked me to be on this panel was, I said, now remember, I am the Brennan Center's chief advocate. I spend lots of time with all the wonderful people in Congress, and I don't spend all of my time, like most of us lawyers do, obsessing over every Supreme Court case. But what that does mean is that the lens through which I view these cases is just a little bit different from the folks who are more academic in terms of their approach to the Supreme Court cases. So what I wanted to try to do was to look at cases in terms of how they are impacting are of importance to the advocacy community, to the many groups that spend day and night trying to work on behalf of communities and clients for whom these cases have real life impact. The first case that I wanted to talk about, and thank you both for not mentioning this, because I said somebody's going to mention this case before I get to it, but it's McCutcheon versus Federal Election Commission. As we all know, this is the case that is succeeding Citizens United, which we know has changed the way in which we view the whole campaign finance reform issue in the United States. McCutcheon is, I think, arguably the most important campaign finance case to reach the Supreme Court since Citizens United did in 2010. And here's something important that you should keep in mind when we look at kind of what the landscape looks like since Citizens United. We know that Citizens United opened the floodgates to outside spending in elections. But what you need to know is this. Independent spending in the 2012 cycle exceeded $1 billion. It's a huge amount of money. Limits on direct contributions to candidates, however, have remained intact. So I always like to throw that out to people because I think it's interesting to see kind of what's happened since Citizens. What we need to know, however, is that McCutcheon could very well change that. In this case, Sean McCutcheon is an Alabama businessman who supports the Republican Party. And he has the desire to provide campaign contributions to members of Congress, to individual candidates running, as well as to the larger Republican National Committee coffers. The individual amounts that he wanted to contribute are in and of themselves not problematic. He was well within the legal limits that one could contribute on a yearly basis. However, when you take those contributions in the aggregate, they far exceed the limits. And that's the problem here. The question is whether these aggregate contribution limits violate the First Amendment of the Constitution. And that's what's being argued here. Mr. McCutcheon, along with the Republican National Committee, argues that the limits burden free speech without a sufficiently important government interest. Namely, what they're claiming is that the aggregate limits do not prevent corruption or the appearance of corruption, and that they do not prevent circumvention of the underlying individual contribution limits. Now, here's what's at stake in this case. Contribution limits represent what we think at the Brennan Center are the last bastion against the corrupting influence of unlimited money in politics, and we've all heard a lot about this lately. If aggregate contribution limits were struck down, an elected official could actually solicit and a single donor could give more than $3.6 million in one election cycle to benefit one party. That's an amount that's more than 70 times more than the median annual family income in the United States. So through joint fundraising committees and inter-committee transfers, this money could easily be used to benefit a few select candidates, and we think this is problematic. So for that reason, this is the case that I'm pointing out as being one of the most important for us to watch. Along with my esteemed colleagues here, I will also say that the National Labor Relations Board versus Canning is one of my three. And I won't repeat anything that they've said, but I will simply add this, that one of the things that we are most concerned about with respect to that case is this, that if this case is upheld, as you've heard, it could undermine the president's accountability for enforcing the law. But finally, the ongoing Senate obstruction that we know and that we've been dealing with has really led to a crisis with respect to our courts. We know that we have a myriad of vacancies in the district court. We have a myriad of vacancies in terms of the appellate court. And this is a crisis that many advocates are dealing with on a day-to-day basis. I know some of the folks that I work with that are here in this room, this is something that they spend a great deal of their time working on. And this is something that we have to be gravely concerned about. So that's one of the other big reasons why that makes one of my three. And then finally, for my third, I wanted to change a little bit and have us focus more on what I like to call the more social justice issues. As you know, at the Brennan Center, we focus on issues of democracy and justice, and this is one that's particularly of importance to us. And it's a case that deals with housing discrimination, mass incarceration, and collateral consequences altogether. And it's the Township of Mount Holly versus Mount Holly Garden Citizens in Action Incorporated. This is a case where Mount Holly Township declared that a particular housing project, the Mount Holly Gardens, were considered blighted. And so they wanted to implement a redevelopment plan back in 2002. What this plan would do is this plan effectively removed the current homeowners from the Mount Holly Gardens, and most of those homeowners were people who were minority and people who were considered poor with respect to our various economic categories. The Mount Holly Garden Citizens in Action challenged this redevelopment plan, and they said they thought it was a violation of the Fair Housing Act. And so they filed a claim and under a disparate impact claim. They alleged that the current plan should be prohibited because it disproportionately affects minority homeowners. The district court, however, dismissed the case because they said the citizens failed to establish a prima facie disparate impact claim here. The Third Circuit Court of Appeals reversed. And what the Supreme Court is now doing is they granted certiorari for the singular issue of whether there is a cognizable claim under the Fair Housing Act. We think this case is particularly important because the Supreme Court, as many of us know, has become increasingly hostile towards disparate impact claims under civil rights legislation. And this is something that, for those who study Supreme Court history, this very much goes against the grain of when many of the original civil rights acts were initially passed by Congress. Should the court render disparate impact claims no longer cognizable under the Fair Housing Act, housing advocates would lose an important tool in fighting discrimination. And it really goes beyond the tool that's available to those who fight on behalf of the underprivileged with respect to housing. It may also negatively affect banking and lending practices as well, as the Justice Department recently enforced disparate impact policies against mortgage lenders as well. So this particular case has a far-reaching effect, or could possibly have a far-reaching effect beyond the Fair Housing Act. So for that reason also, I put this among my top three.
Great. Before we move on to the next topic, I just want to list a couple of, quickly, cases that are near and dear to my heart. I like to try to focus on criminal justice cases. I do most of my writing on it. And there are three cases that pop out to me. The first is Burt versus Titlow, which is a plea deal case. There are a lot of movement in the area of plea deals and their inadequate representation, and when criminal defendants have to be told of deals and when they should be given the option of taking plea deals. I just finished writing for The Atlantic a piece about a terrible story in Ohio involving the death of a death row inmate who committed suicide roughly 36 hours after prosecutors in the case learned that there may have been plea deal negotiations in his case 25 years ago that he was never told about. So the Supreme Court is going to, again, have to address some of this stuff. It's a case that comes early in the term. I think it's an important case. Cayley versus U.S. is a case about freezing assets. And anyone who has been paying attention to what's going on with respect to the process of restitution and the way that the authorities can basically take your property before you are charged, before you are indicted, before you are convicted, this is a case that has ramifications for that. The idea that you basically lose your property. It's impounded, and it basically creates a for-profit incentive for the police. It's something the Brennan Center has written about. It's something a lot of folks have been writing about quite a lot lately. And then the third case is not a case that's yet been accepted. It's up for conference next Monday, and it's the Warren Lee Hill case out of Georgia, which I have focused on a lot. Warren Lee Hill is a intellectually disabled man. The law uses the term mentally retarded. It's an outdated term, but the court uses that term. And of course, 10 years ago, the U.S. Supreme Court outlawed the execution of such people. Here's the guy who comes along. There are no longer any medical experts who believe he is not intellectually disabled to the point where he is, quote unquote, mentally retarded, and yet Georgia wants to execute him. The Supreme Court has been asked to take the case. It's been asked to take the case for a couple of different reasons. It's an opportunity for the U.S. Supreme Court, it seems to me, to either affirm Atkins versus Virginia, which is the case that held that these folks could not be executed, or to acknowledge that they no longer want to follow that case and to basically overturn it. So Hill versus Georgia, it may be Hill versus Hurd, but that's a case to watch next week to see if the court takes it and if it does, what it will do with it. So let's continue on now. Sleeper cases. These are the cases that maybe are going to fly under the radar. Maybe they don't have a political component to them, but maybe you've identified them in various ways that you think folks should keep an eye on. I know I have a couple, but I want you guys to go first. You're up.
Okay, well, Burt versus Titler was
Oh,
actually
I'm
one of
sorry.
my sleeper cases. I'll just say a couple more words
Sure,
about
absolutely.
it. It is a case in which a woman was charged with first-degree murder. Her lawyer worked with her. They got a plea deal. And then she talked to a sheriff's deputy who said, if you're innocent, you shouldn't plead guilty. You need to get a new lawyer. So she got a new lawyer. The new lawyer did no investigation whatsoever, went with her to withdraw the plea. She wound up going to jail and getting a much longer sentence. And the Michigan court said that's okay. It's not objectively unreasonable, even if the lawyer doesn't do any investigation at all, if the defendant proclaims his innocence. And so this takes a standard that was laid out in a couple of cases 2 terms ago involving plea deals and ineffective assistance of counsel, and would really lower the bar for when you could get some relief when you had an ineffective assistance of counsel at the plea bargain stage. And given A, how many defendants proclaim their innocence, and B, how many cases wind up in a plea bargain rather than going to trial, it could have a significant impact. The second 2, I promise, are also real sleepers, and just as with the abortion cases, I think the combined effect of them could really be significant. I don't know about all of you, but one of the things that struck me after I'd had a chance to read the decisions in Hollingsworth versus Perry, the proposition case last year, and you read the majority opinion saying no standing, and you read the dissent saying standing, is that it didn't really line up in terms of what you might expect from some of the justices. That you had justices like Justice Ginsburg and Justice Breyer and Justice Kagan, whom we normally associate with trying to make sure that people can get into court, keeping the proponents of Proposition 8 out of court. And then you had justices like Justice Scalia and Justice Alito on the other side saying, yes, these people should be allowed their day in court. And so these are a pair of cases about personal jurisdiction. And they're both out of the Ninth Circuit. Depending on how they go, they could make it either harder for people to get into court and bring their cases, or not at all. I should add that both of these cases, my husband and his law partner, my former law partner, are involved in, but I'm not involved in them at all. The first one's a case called Walden versus Fiore that involves some professional gamblers who were coming back from Puerto Rico with $97,000 in cash. It was completely legit, and they had documents to prove it. They passed muster when some law enforcement agents stopped them in Puerto Rico, but then were stopped again by a local police officer who was deputized as a DEA agent in Atlanta. He asked them some questions. They answered the questions. He seized the money. They went back to Las Vegas and tried to get it back. They sent him documentation. Eventually, they got the money back after he filed what the U.S. Attorney's Office found to be a false probable cause affidavit to keep the money. So then they sued him in federal district court in Nevada for Fourth Amendment violations. It was a Bivens action. And the district court said, no way, no personal jurisdiction here. The Ninth Circuit said yes. There is personal jurisdiction, and so now the Supreme Court's going to flesh out the scope of a 1984 decision called Calder versus Jones. What does it mean to have conduct that's aimed at a foreign state? So that's the first case. The second one is a case called Daimler-Chrysler versus Baumann, in which Daimler-Chrysler, Mercedes-Benz to most of us, is being sued in California for the actions of its Argentinian subsidiary in Argentina. And the question is whether or not there's personal jurisdiction. This case was something that sat around for quite a while the court resolved the Kiobel case involving the Alien Tort Statute. And the court in that case, as many of you may recall, said that in that particular case in which you had a foreign defendant, a foreign plaintiff, conduct that occurred overseas and no real connection to the U.S., the case can't go forward. And so there's a possibility that they could use this as an opportunity to further explain what kind of connections do you have to the United States. They could also use it more broadly about personal jurisdiction questions in general and whether or not exercising jurisdiction over Daimler-Chrysler when it's got this indirect subsidiary in California is something that violates due process. We saw a lot of opposition at the oral arguments in the Kiobel case to this idea that the U.S. courts should be these sort of world courts, or anybody with a grievance can come, and we are likely to see, I think, some of that opposition again. Oh, yeah.
Again, I'm kind of oblique to the sleeper issue because I tend to focus on the high-profile cases. But I do think there are some high-profile or relatively high-profile cases that may turn into sleepers. That is, the opinions may put you to sleep. And the interesting question there is, it will show us a little more about how serious the Chief Justice is in his oft-stated philosophy of judicial minimalism, that courts should decide narrow issues and so forth. His track record is a little spotty in that regard. The first one that's worth looking at is, again, Madison versus Levine. This actually is slightly a sleeper anyway. It's not attracted a lot of amicus briefs and press attention. This, again, is the case about age discrimination. And one of the options the court has is to follow an amicus brief that's been filed for a series of law professors saying this case doesn't belong in front of the court because the appellate review was granted to an issue that only existed under pendant jurisdiction. Now, if there's anything that puts people to sleep faster than pendant jurisdiction, I, as a former teacher of civil procedure, haven't found it. But it would offer the court a chance to duck, sort of from a clear blue sky, talking about the meaning of the Equal Protection Clause when it comes to age, and it'll be interesting to see if they take that. The second one is Town of Greece versus Galloway, which is a case that has to do with a town council that had invocations before each meeting, and they said the invocations were open to everyone, but they actually never told anybody that, but they did call all the religious bodies within the town limits, all of which were Christian, and invite them to participate, so that you had a 9-year period where only Christian prayers were offered, many of them very explicit and sectarian, and inviting people to make a personal commitment or whatever. And the question is going to be whether the court decides this under the existing framework of religion clauses, or whether with that bothersome Sandra Day O'Connor finally gone, they can go to a much broader endorsement of public acknowledgement of religion in public life, and that's worth looking at. And the third one, which is not a sleeper in practical terms, though this could be a truly anticlimactic result, is Noel Canning, because in fact the court has a way of deciding the case that ends up not letting us know about the NLRB appointments, which are now moot because we've got an NLRB that's confirmed. And the Solicitor General has asked the court not simply to vacate the D.C. Circuit opinion on the grounds that it's incredibly broad. Basically, the D.C. Circuit said, we think we'll just wipe out the recess appointment power. Why not? Got nothing else to do. And the Solicitor General says, just vacate that opinion and remand on the issue of whether these particular appointments, that is the so-called pro forma session appointments, are valid, in which case the case, in essence, goes away as a big constitutional showdown among the branches. So those are the ones I have my eye on to see if maybe they will disappear. and sort of hoping in each case that they will.
My first sleeper is a case called Shewitt versus Coalition to Defend Affirmative Action. And I put that on my list because, one, I think probably most of us thought that after the court dealt with Fisher, that we were kind of done with affirmative action for a little bit, but I don't know that we'll ever be done, at least in the near future, with affirmative action. So I wanted to put this case on people's radar. Shewitt is a case dealing with the state of Michigan. In 2006, Michigan voters adopted a referendum called Proposal 2, which prevents the public universities from adopting race-conscious admissions policies without first amending the state's constitution. The ensuing litigation has disputed whether this constitutes a special burden upon minority voters wishing to participate in the political process to enact such admissions policies. In this case, the district court held that the referendum was constitutional, but the Sixth Circuit reversed on the grounds that this frustrates participation in the political process in violation of the Equal Protection Clause of the U.S. Constitution. So the Supreme Court granted certiorari here to determine whether the state violated the Equal Protection Clause by amending its constitution to prohibit race and sex-based discrimination or preferential treatment in public university admissions decisions. Michigan's legislation basically renders constitutionally permissible, though not required, affirmative action policies more difficult to enact. And so for that reason, we want to watch and see what happens to this case, because perhaps other states like California, which we know is very adept at introducing propositions and other types of proposals, we want to see whether other states might follow suit with respect to Michigan. And this case is particularly of interest to the Brennan Center because, like many other organizations, we followed Fisher closely and we filed an amicus brief in that case. And we obviously think that diversity in higher education is a compelling interest and is something that should be encouraged. So we want to pay close attention to this case and see what happens. The second of my cases is United States versus Blewett, which is a case that deals with the retroactive application of the Fair Sentencing Act. Many of us remember the disparity that existed for many years since the 80s between sentencing for violations dealing with crack versus powder cocaine. There was a 100-to-1 disparity. In 2010, Congress enacted the Fair Sentencing Act, which didn't equalize the sentencing, but it did lower the disparity. So now what we have is a 100-to-1 to an 18-to-1 ratio with respect to sentencing for crack versus powder cocaine violations. However, when the Fair Sentencing Act was enacted in August of 2010, what it basically said was anyone who was sentenced after the enactment of this law will be under different sentencing guidelines. But for those people who were sentenced prior to that, they were people who had different sentencing structures and had to deal with the issue of mandatory minimums. And we think harsh mandatory minimums at the Brennan Center, as with many other organizations, have been declared draconian and they're unduly harsh in the eyes of Congress. And we are very grateful and excited by the fact that our own Attorney General, Mr. Holder, has been speaking most recently on these issues. Everyone, I'm sure, heard about his speech at the American Bar Association's annual meeting in San Francisco, where this was one of the big issues that he wanted to focus on. We think that this is a close one to watch. And my third case is a case called Wilbur versus Mount Vernon. This is a case dealing with the indigent defense system. This, as we know, is the 50th anniversary of the Gideon versus Wainwright decision, which is the preeminent case that says that in this country, if one is accused of a crime, one is due adequate defense. However, one of the things that we have been seeing most recently is that our indigent defense system in this country is very, very much under fire. The federal defenders, for instance, are seeing most recently a 50% cut in their staffing. So this is a crisis. If you talk to people who work on indigent defense within many of the states, they will tell you that their state defender systems are very much in need of additional support. Their caseloads are overburdened, and it's becoming increasingly difficult for these defenders to actually ensure that individuals are getting the adequate representation that they need. So those are the three cases that I think we need to be paying very close attention to.
And I'm just going to really quickly give you my three so that we can do the final group, and then we can open it up to questions. I'm surprised that nobody mentioned Sandifer versus U.S. Steel, which is a case about, it's a union case. It's a case about employers and employees changing clothes. When you have to change clothes for your job, does it count as time? Does it not count as time? You know, to me, that actually is a double category for me, because I think it's going to be an interesting case. I think it's going to generate an interesting dissent, and I can just picture reading Justice Ginsburg's dissent in it. So that's something to keep in mind. There's also a Fifth Amendment case. Garrett and I were talking before about this court and the Fifth Amendment. It's out of Kansas. So you have a methamphetamine abuser who kills a police officer, sheriff, admits to it, says, I was under the influence of the methamphetamine. It somehow, minimizes the criminal intent that I had, and that's his defense. The state says, okay, Buster, if that's what you're going to argue, we're going to use the mental health evaluation that was performed on you as rebuttal evidence. And it worked. And there was obviously a conviction and a lengthy sentence. The Kansas Supreme Court reversed the results of the trial, saying that the Fifth Amendment rights of the defendant had been violated, that there were barriers the U.S. Supreme Court had put into place to avoid having your doctor testify against you without you waiving your right. And they said that the use of his argument, his defense, didn't waive the right. I mean, to me, that screams out for a reversal from this court. It's something to watch for. I guess the case is called Kansas versus Cheever. And then finally, I was a little surprised that nobody has yet mentioned the Clean Air Act case. I haven't spent a lot of time focusing on it. I'm sure it's something we're going to cover down the road. But, Clean Air Act, Environmental Protection Agency, downstate, upstate, winds of change, and so forth. To me, that is a case that probably is going to get more attention the closer it gets to the oral argument than it has gotten so far. That's one of those cases that's going to sort of pop up on people, but it's going to be very much on everyone's radar. So let's go now to the final list, and this is probably the most amorphous of all of them. As you look towards the term dissent, what are the three most likely dissents in what are the three most likely cases? I know it's impossible to tell who's going to dissent in any given case, but still, let's try.
Oh, but it's fun.
Yes,
so
it is.
We'll do it.
Exactly.
And just sort of to set up, to explain two of my choices, the way that the court works is that when they have their conference, the justices go around and vote, and the senior justice in the majority gets to assign the majority opinion. The senior justice in the dissent gets to assign the dissenting opinion. So now when there's a traditional sort of 5-4 conservative liberal breakdown, Justice Ruth Bader Ginsburg is now the senior justice in the dissent. And she talked about this a little bit in the speech that I mentioned earlier, that she has inherited this role from Justice John Paul Stevens, and I think she's really enjoying being the leader of the court's liberal wing. So two of the dissents that I'm going to mention, I think, will be hers. She's going to dissent in Klein, the Oklahoma medical abortion case, and I think it's going to be sort of a warning to the effect of, the court is very gradually paring down abortion rights, and, make no mistake that this is an important case. I think she's also going to dissent in the Schuett case. She was the only justice who dissented in the Fisher versus University of Texas case. Justices Breyer and Sotomayor joined the majority in that case, and Justice Kagan was recused. Justice Kagan is recused again, but it'll be interesting to see, there had to have been some strategy in the Fisher case. The Fisher case was argued in October, and then we got a 13-page majority opinion in the last week of the term. And so I think there was maybe some horse trading, some compromising going on, and Justices Breyer and Sotomayor maybe went along with the majority opinion to try and keep it from being too draconian, so it'll be interesting to see what they do again. The third opinion, I think, will be Justice Kagan's dissent in the McCutcheon case. She did a very eloquent dissent in the Arizona Free Enterprise Club's Freedom Club versus Bennett, which was the challenge to an Arizona law that provided matching funds if you were a candidate who received public funds whenever either the privately financed candidate or the independent groups went over a certain expenditure level. And so I think she'll be writing again in McCutcheon.
Garrett, you're up.
Well, two of the three have just been of my three have just been
Sorry.
covered. No, this is good, but I
More
have
time for
one. I
questions.
have one that nobody has addressed at all, and I can just not only see Justice Breyer's dissent, I can practically write it. And it's a case that no one has talked to, and it's called Unite Here Local 355 versus Mulhall, and it has to do with the in which an employer enters into an agreement with a union that during the organizing campaign, it will refrain from certain practices. It will not encourage its workers not to join the union. It will not bar union organizers from property and so forth. And this is part of a negotiating, even though the union has not yet obtained a contract, they're negotiating to the extent, what job actions are you going to take against us? What picket lines will you take? Will you cut us some slack if we do these things? And this was appealed to the 11th Circuit, and the 11th Circuit, which is one of the more conservative in the country, held that this violated the National Labor Relations Act because the union, in essence, was extorting things of value, which is forbidden under the NLRA. You can't demand money from an employer. Say you can't come in and say, well, it'd be a shame if there was a strike here, but you give us some money. That's what the law is intended to do, right? But now they say, well, the free speech rights of the company are a valuable thing, and they are bribing the union with this, and this is corrupting the union. And one of the things that doesn't get written much about this court is how resolutely anti-labor it is, and they remind me a little bit of a crime family in the sense that before they whack you, they send you a bullet. They let you know that you're next. And they have done that. They've done that with the labor movement in a case called Service Employees Union, International Union versus Knox, in which they basically begin to import First Amendment analysis into the labor union category. That is to say that designating a union as a bargaining agent now becomes a potential violation of the First Amendment rights of members of the union, of people who don't want to be members of the union. And so it is possible that the court may use this opportunity to extend First Amendment analysis into this and say, that the employer's First Amendment rights are things of great value that cannot be bargained away during the collective bargaining process. If that happens, Justice Breyer, who wrote the dissent in Service Employees International Union versus Knox, will write the dissent here. He seems to be the only one of the nine who has a really lively feeling for the imperatives of labor in the modern workplace. And I can just hear him reading it in his voice from the bench. So that's one to keep an eye on.
Like my fellow panelists, I think the most interesting dissents will come from both Schuett and McCutcheon and from the same justices that you already focused on. And it's funny because given my third one, which I'll tell you about in a second, I think it's the women on the bench who are often giving some of the most interesting and compelling dissents. So to Schuett and McCutcheon, I will add finally as my third, Sotomayor's dissent that I think will come in Township of Mount Holly versus Mount Holly Garden Citizens in Action. And that's mainly because for those of you who have read her book and her history, Justice Sotomayor herself grew up in a public housing project in New York. And one of the things that I'm often engaged in conversations with people about the court, and one of the criticisms that I hear from people is that so many of the justices don't have the same real life experiences that many of the individuals whose cases are coming before them have. Well, this is an instance where Sotomayor indeed has an experience. She knows what it's like to live in a public housing complex. She understands what it means for the residents to have to band together and fight on behalf of their combined interests. So I don't see the court necessarily ruling in favor of the residents, but I do think that given her background and her particular sensitivity to these issues, that she will probably have an extremely compelling and interesting dissent in that case.
It's interesting that we didn't hear one conservative dissent, right? And I think that's a reflection of the court's makeup, and I think it's probably a reflection of the difficulty in predicting when Justice Kennedy is going to decide, one way or the other. So what we wanted to do is we wanted to give you guys plenty of time for questions before the 2 o'clock bewitching hour when you're all free to leave. And so if you have questions, just raise your hand and stand up and let us know which of the panelists you want to address your questions to, and we will. Oh, we have a microphone. We have 2 microphones. Look at us. Look how prepared we are. More prepared than I thought we would be. So you can just raise your hand and we'll get you a microphone, and we can go from there. Don't all jump at once. I think all that turkey is setting in and you're all dozing off. No one has any questions? Garrett has that? There you go, Richard.
Well, I'm a journalist, so I'll start it and then everyone else will jump in. I was just wondering, based on those dissents, I'm sorry, I'm Rich Wolf with USA Today. Do you think that there are any surprise decisions coming? That could have been a 4th category, because all of the dissents you just mentioned were probably predictable decisions of maybe 5-4 conservative rulings. Are there any cases where you think, particularly any of the more high-profile cases where you, other than NLRB, where nobody knows where any of the justices are going to be, are there any cases where you think that we might have a Kennedy switch or a Roberts switch? Some people mentioned Roberts on McCutcheon as a potential. Are there any of those where the dissent would not be what you would expect, but it might be a dissent from the right?
Anyone?
I see this court as having gelled. I don't know if you've read Marcia Coyle's book, The Roberts Court, where she says at the end of the term she writes about, which is the healthcare term, she says that it is no longer an Anthony Kennedy court. This is the Roberts Court. And I think the political valence on this court has moved very far to the right. And Justice Kennedy is very far to the right. I don't see him particularly as a swing justice anymore. So I think, I'm not saying that there won't be surprises. What I am saying is that, if you're going to the $2 window on any particular case, don't bet on the surprise. And so I haven't seen one where I say, oh, yes. I mean, I see virtually no case where I say John Roberts is going to side with the liberals. I think there's only been one in his career. You have the statistics. Yeah. And so given that Justice Kennedy seems to be becoming more conservative, I think the smart money is on 5-4, 5-4, 5-4.
Yeah, and I would just add, like in the campaign finance case, I sense that we're going to be looking at a 5-4 decision, and the discussion that day or the next day is going to be, did they go as far as they could have gone? Was it as bad as we thought it would be? That kind of stuff. I think that's going to be the dialogue in the wake of that decision, for example, where folks who are in favor of campaign finance regulations are going to say, well, it could have been worse, this could have happened, and the folks who are against it are going to say, wow, this is another good step in that direction. I just think that's the dynamic in play, and I agree with Garrett. We call Justice Kennedy the swing vote. I do, because occasionally he does side with the more liberals, certainly more than most of his colleagues. And I also think Garrett's right that the switch in this court came when Justice O'Connor was replaced by Samuel Alito, who is profoundly conservative and in some cases aggressively so.
I mean, and I think when we talk about Justice Kennedy as the swing vote, you have to recognize that we're talking about him as the swing vote in particular kinds of cases, gay rights, something like the death penalty for minors. But, this is not somebody who's a swing vote in most criminal cases. It's not somebody who's going to be a swing vote in McCutcheon. And I completely agree that McCutcheon, I think of as sort of a rerun of Fisher versus University of Texas. At the point that they granted cert, we knew that it was going to, nothing good was going to happen to the University of Texas's admission policy. The question was just, how bad is it going to be? Are they going to overrule Grutter? And in the end, of course, they didn't, but they've put a lot of teeth into it that weren't there.
And I will say this, I don't have any predictions with respect to your question, but I will say this. The Chief Justice I find very interesting in that he is very concerned about his legacy. And I think I, like many people, were very surprised about the healthcare decision, and in terms of him being the person who wrote the opinion. And I think that kind of lends itself to us kind of keeping a close eye on him in terms of looking at, in big, huge cases like McCutcheon, where there's an opportunity to really just change the lay of the land in terms of some big policy issue that really affects us gravely. I think we want to watch and see what is it that he wants to say about his legacy, and does he want his legacy to be that of the Chief Justice who undermined policies and practices that Americans have depended on for so long? Does he want that to be part of his legacy, or does he want his legacy to be that of a Chief Justice who actually continued to provide some protections for the American public as they know them? So for that reason, I just think we should continue to watch and maybe not be so surprised by what he does.
So we didn't really answer your question at all.
Which is the purpose of a panel like
Exactly.
this. And the purpose of being a lawyer.
And the purpose of law school.
Right, exactly. Yes, ma'am.
So far you
Hold on, why don't you wait for the microphone so that
We can hear you. But
Yeah, we can. Thank you.
So far, you guys have discussed split decisions. I'm wondering if there's going to be any unanimous decisions, probably a case that you haven't discussed since everything so far has been 5-4 predictions.
I wouldn't be that surprised actually to see a couple of the personal jurisdiction cases that I talked about go 9-0, that even the liberals are willing to sign on and say, you've got to have, here's personal jurisdiction. And this is Justice Ginsburg's sort of bailiwick in particular, some of the civil procedure.
I'm not going to make any specific predictions, but I will say that if you go through the excellent statistics provided on the scotusblog.com website, you will see that the number of unanimous decisions the trend is quite clear. It's on the rise, and it reached 49% last term. So, we should expect a good deal of decisions. There's some kind of weird harmony inside this court. When they take their teeth out of each other's necks, they're all like, let's go hunting and go to the opera. And this seems to be reflected on the bench. At some points during the Rehnquist court, the percentage was as low as 19%. So it's quite a strike, a change.
And I'll give you a specifics. I mean, the first week they have these Securities Litigation Uniform Standards Act cases. There's 3 of them. Speaking with our horse analogy, if you want to put $5 on some sort of trifecta or quinella there, you probably get a unanimous decision.
And I'm not expecting unanimity with respect to any of the cases that I've talked about. But I will add a caveat to what you just said, Garrett. I think perhaps if members of Congress did a little more hunting and fishing together, that perhaps we'd get some unanimity there.
I'm in favor of that.
But it is kind of a fascinating thing that so many of the bread and butter cases of the court's docket come to the Supreme Court precisely because different courts have reached different conclusions. Right. And then they get there and they're like, 9-0, 8-1. The Chief Justice talked about being an umpire who calls the balls and strikes. And these are hard decisions. You've had smart judges in the lower courts who've reached conflicting views on them, and yet the Supreme Court's able to look at them and say, right answer, wrong answer, pretty easily.
And don't forget, too, the court is these days taking roughly half the number of cases that it took 30 years ago during the Brennan era, the Warren era, half as many cases, which also impacts the statistics a little bit, I'm sure.
Question for Nicole, and I'm wondering whether you'd accept something of a refinement on your observations about Chief Justice Roberts' motivations, and that while I would agree that he's concerned about a legacy, what he's not so much concerned about is being known as the justice who ran a court that contributed to the undermining of a lot of important principles that we've always held as dear, but being the justice who ran a court that was activist enough to undermine these. In other words, his focus is not so much on the doctrines that many of us would hold as dear as it is on the character of the institution itself.
I will accept that amendment. Yes, that friendly amendment. Andrew, I'm sorry. No, go ahead.
Go ahead.
No, please. We want to hear from you.
Okay. So you mentioned that we're in the fourth inning now. Let me ask you to go a little further out on a limb and predict what's going to happen in the ninth inning. Do you see any cases on the horizon that the court has not granted cert yet that you think will come up and have a significance at the end of the term?
Great question. I'll let you.
Yes, there are. I mean, I think some of the best ones are yet to come. I think the big one is the challenge to the contraceptive mandate of the Affordable Care Act. Two dueling petitions have already been filed, one by the U.S. Garrett, that's mine. Sorry, I think I stole your water.
They're all
We're close, but, and so, again, Third Circuit said the contraceptive mandate is constitutional. The 10th Circuit said it's not. So I think you can basically book that one for sometime in the spring.
what she said.
And it's funny that you were the next questioner and that you and I kind of did this, no, you go, because that's literally what I was going to offer. I was going to say, I got so carried away in an earlier part of our conversation that two of the cases that I talked about as sleepers are actually cases that I want us to keep an eye on because they have not yet granted cert, but I think they're cases that we should keep an eye on, and that's the Blewett case and the Wilbur versus Mount Vernon. But I would be remiss if I did not talk about voting, given the work that the Brennan Center does on voting rights. We all know what happened this past term in the Shelby County case and what happened to Section 4 of the Voting Rights Act, which has now basically turned Section 5 of the Voting Rights Act. It's basically taken away all of its teeth. And for those of you, I'll just say quickly, Section 5 is the part of the Voting Rights Act which basically said that states that had a history of discrimination with respect to voting had to have any changes in their laws dealing with voting pre-cleared before a federal court or by the Department of Justice before those changes were implemented. Now we are all dealing with the aftermath of that. Many of the states, as you know, came out immediately after the Shelby County decision and said we are going to now implement some of the voting changes that were being previously blocked. So for that reason, I think we need to keep an eye on what's happening in both Texas and in North Carolina. In Texas, only hours after the Supreme Court handed down the Shelby decision, their Attorney General went on TV and announced that they would reinstate their voter ID law, which had previously been blocked by the federal government. The Department of Justice has since filed legal challenges to that law, invoking Section 2 of the Voting Rights Act. And Section 2 is a part of the Voting Rights Act which is applicable to the entire country, not just certain states that have a history of discrimination, but to the entire country. So we need to watch that, and we also need to watch a pending challenge to Texas's restricting efforts. And then finally, in North Carolina, their lawmakers had previously passed an onerous election law that institutes a very stringent voter ID requirement. It also slashes the number of early voting days and restricts the groups that can sign up voters and makes some restrictions with respect to absentee ballots. So we need to keep an eye on what's happening in North Carolina as well. There are other states that the Brennan Center has done some research on that we know are going to be introducing some similar legislation, but with respect to the ones that are immediately up and coming, Texas and North Carolina are places where we need to keep an eye on those cases.
And if I can say something about that precise issue, one thing to be aware of when you study and watch these cases, because you're absolutely right, they are important sleepers, is that Chief Justice Roberts' very first assignment when he joined the Reagan administration as a 28-year-old lawyer was to oppose the broadening of Section 2 of the Voting Rights Act, which was broadened during the 80s to include a so-called effects test, which is sort of like the disparate impact test. And his memos on this are scathing. He regards the Section 2 as much too broad and much too intrusive on state prerogatives, and he made reference to this in the opinion in Shelby County versus Holder. There is a throwaway line about how, my God, they're already subject to this horrible requirement of the effects test in Section 2. Now you want to have pre-clearance. This is just awful. So the Voting Rights Act, may not be done with it. This is a real point this is a point that Roberts takes very seriously for whatever reason.
And I just want to make, when we talk about predictions, it's going to be very interesting to see how the media and the public perceive this term. This is not a term where there's a gay marriage, that everyone was waiting for, or the Voting Rights Act case that everyone was waiting for, or the Affordable Care Act decision that everyone was waiting for. People are interested in
in the campaign finance, yes, and people will get more and more interested in the abortion cases, especially if they come. But this is going to be a term that's not going to get as much mainstream attention, I don't think, as the past couple of terms have been. Doesn't mean that the cases are going to be any less significant. Doesn't mean that the law isn't going to get changed in any less meaningful way. I just think that the attention for the average person is not going to be focused as much on the court this coming term, unless something dramatic changes, than it has been in the past couple of terms. My sense is that the past couple of terms have brought extraordinary attention to the U.S. Supreme Court because of the subject matter of some of those cases. And, we try to sex up pendant jurisdiction. Amy's always trying to sex up pendant jurisdiction, but or personal jurisdiction. But I'm just not so sure that most people are going to be buying it. And that's going to be a challenge for those of us who cover the court, for those of us who pay attention to the court, to try to translate it. Yes, sir.
I know that several of you said that the split in the decision would be sort of quirky in the Noel Canning v. NLRB case, but do any of you think that the breadth of the lower court opinion will be upheld in its entirety, right? I mean, so not only that a proper appointment has to happen in an intersession recess, but that the actual vacancy has to occur as well in the intersession recess, which is unusual for like decades of precedent. And if so, what would be the sort of post hoc like limit for how many would be possibly invalidated? I mean, what would be the statute of limitations for where the invalidations would begin?
I frankly don't expect them to go all the way that the D.C. Circuit went. I think that court really went rogue. And I think that the Solicitor General's brief offering them the option of voiding the opinion and remanding might seem very attractive to them, because this is an issue that's going to have a lot of practical impact, and it might be good to develop it slowly. That said, I can write Justice Thomas's dissent, from that, saying, the original understanding was blah, whatever it is, and so it's not impossible that will attract. I don't know. I'm not sure I see that attracting 5 votes, but it's not impossible.
Well, that's it, guys. Oh, we have one more? We'll take one more question.
Sorry, one more question.
Okay.
I'm Susan Frederick, and I'm from the National Conference of State Legislatures. And one of the reasons that I follow the Supreme Court is to sort of discern, if I can, trends in federal-state relations. So I know over the last several terms, the court has kind of gone both ways, depending on the issue, either favoring or upholding state law or overturning state law. So I'm wondering, and I throw this out to the panel as a whole, if any of you would like to take it on, what you kind of foresee for the cases this term. There are many cases that implicate questions of state versus federal authority, and how you view the court coming down on those cases.
I'll let Amy or Garrett answer, Nicole. Nobody wants to touch it. Well, to me, it's still a court that's more likely to respect states over federal authority and power. There have been some exceptions, obviously. Shelby County was the latest example of federalism and the 10th Amendment, and the idea that states' rights ought to be. On the other hand, you can point to the Arizona decision, that goes the other way. That's the best I can do.
The two that I have thought about this in connection with are Chouette, first of all, where they might say, look, the voters of Michigan have a right to orient their university governance however they want. And that will be interesting. I think the language in the decision in Bond will be very interesting, because the question is whether the court begins to talk yet again about areas of traditional state sovereignty. Gradually, they're erecting these kind of warning signs around certain things for federal power that weren't there before. And so I've got my eye on that one.
Yeah, and I was just going to mention Chouette.
Yeah.
So as I talked about earlier, I think that's one we absolutely have to watch and see what happens.
Well, thank you guys for coming. We really appreciate it. You were wonderful. Thank you.